The committee will come to order, and we'd like to welcome our colleagues back from the break and also our folks on the first panel. Before we get down to my opening statement, I want to ask unanimous consent to submit for the record the August 13th, 2013 decision of the U.S. Court of Appeals for the D.C. Circuit to issue a writ of mandamus. I also, without objection, so ordered. I also ask unanimous consent to submit for the record an August 20th editorial by the New York Times entitled "Time to Stop Stalling on Nuclear Waste." Without objection, so ordered. I also ask unanimous consent to submit for the record the letter that Chairman Upton and I sent to the NRC on August 23rd discussing the recent decision of the U.S. Court of Appeals for the D.C. Circuit and the NRC's response dated September 6, 2013. Without objection, so ordered. Lastly, I ask unanimous consent to submit for the record the letter that Chairman, that's one I mentioned. Then finally, Chairman Upton and I received a letter from Ranking Members Waxman and Tonko indicating their desire to examine the status of Fukushima nuclear plant in Japan. We look forward to discussing those issues with the full commission when they appear this fall. And so we want to thank you for that input. And I'd like to recognize myself for 5 minutes for my opening statement. On August 13th, the U.S. Court of Appeals for the District of Columbia Circuit granted a writ of mandamus stating that, and I quote, "The Nuclear Regulatory Commission must promptly continue with the legally mandated licensing process." The purpose of our hearing today is to examine the next steps for the NRC and the Department of Energy to implement the court's decision. Thank you, Chairman McFarland and Assistant Secretary Lyons, for your testimony today. In its decision, the court rebuked the NRC for, and I quote, "simply flouting the law," end of quote, something this committee recognized long ago. How is it that an independent agency with a clear statutory responsibility is criticized by a federal court for having, and I quote again, "no current intention of complying with the law," end of quote. Today's hearing will be focused on looking forward, but we have to be cognizant of the agency actions that led to this situation and vigilant against resurgent efforts to undermine the statutory process. The Commission's recent order to give the parties until September 30th to comment on how the NRC should proceed, however well-intentioned, is eerily reminiscent of past NRC efforts to slow the review process and to stall the release of its safety evaluation report. On June 3rd, 2008, the DOE filed a license application for construction authorizing to build a repository at Yucca Mountain. NRC accepted the application and docketed it on September 8, 2008. By the end of 2009, it was becoming clear that the DOE would close down Yucca Mountain program, abandoning the 30 years of research and $15 billion invested. By March 3, 2010, the DOE filed a motion to withdraw the license application in a manner that would prevent any further consideration of the site. On June 29, 2010, the NRC's Construction Authorization Board denied DOE's motion. In spite of this, then NRC Chairman Greg Yasko was already laying the groundwork to unilaterally cease the NRC's review of the license application, as we learned in our hearing, to review the NRC Inspector General's report on this subject. According to the IG's report in spring of 2010, NRC staff informed Chairman Yasko that they were ahead of schedule and could issue SEER Volumes 1 and 3 earlier than the previously projected dates of August and November 2010. This is very important information. In fact, the NRC Executive Director had the impression that Volume 3 would be ready for publication in the summer of 2010. In June 2010, Chairman Yasko directed the staff in a memo to maintain their public schedule and not issue Volumes 1 and 3 early. At that point, it was clear to the Department Executive Director that the Chairman planned to close down the license review on October 1st, and that, and I quote, "the practical effect of Chairman's June memorandum was that it prevented the staff from issuing Volume 3. Should it have been finalized prior to October 1st, end of quote. Indeed, on October 4th, Chairman Yasko directed the staff to cease its review of the license, citing the continuing resolution even though the CR would continue to provide funding for the review at the existing level of $29 million. He later told the IG that it was his responsibility to manage the agency's workload and workflow with regard to scheduling. Here we are nearly a month after the D.C. Circuit issued a writ of mandamus, and the NRC's only action we've seen so far is to invite the parties to comment by September 30th. Electricity consumers and taxpayers have waited 30 years and paid $15 billion to find out whether our independent nuclear safety regulator concluded that Yucca Mountain would be safe or not. Releasing the SEER is the next step in the NRC process. The NRC has the money to do it. A federal court has ruled that the NRC must proceed, and the NRC says, hold on, let's ask the parties what they think. This does not seem like the posture of an agency intent on complying with the writ of mandamus. Instead, the NRC appears again to be stalling. I won't speak for other members on this committee, but I want to be very clear. I strongly believe that the NRC's first order of business is to complete and release the safety evaluation report. Transparency in this matter is essential to rebuilding the agency's reputation as an independent and objective regulator. And with that, I yield back the balance of my time, and I yield to the ranking member, Mr. Tonko, for 5 minutes.
Thank you, Chair Shimkus. Good morning, everyone. And the United States Court of Appeals has now issued a ruling ordering the Nuclear Regulatory Commission to resume its review of the Yucca Mountain license application. I do not think this action alone has resolved much related to the ongoing questions about the fate of nuclear waste. The court decision does not reverse the opposition to the Yucca Mountain project in the state of Nevada. It does not require the NRC or DOE to move forward without additional appropriated funds. And at this time, there is still a possibility that one or more of the parties to this case will appeal the ruling. It seems we all still have a great deal of work to do if we are to move nuclear waste policy forward. Yucca Mountain may or may not be part of this policy. Even if it is, we are still many years, perhaps decades, from placing the first waste into this repository. If nuclear power is to play a role in our future energy supply, we need to explore other options for dealing with this waste that could be implemented more quickly. I do not expect we will resolve anything today. I hope we will be able to move forward and work together to find a constructive solution to this very critical, very important problem. I want to thank Chair McFarland and Dr. Lyons for appearing before the subcommittee today, and will yield my remaining time to the gentleman from Texas, Mr. Green.
Thank my colleague and our ranking member for yielding. Mr. Chairman, thank you for holding this timely hearing on nuclear waste in Yucca Mountain. I also want to thank Chair McFarland and Assistant Secretary Lyons for joining us this morning. Earlier this year, Chair McFarland and her fellow commissioners before this very subcommittee committed honoring the court's decision concerning the review of Yucca Mountain license application. Since that time, the D.C. Court ruled that the NRC must resume its review in accordance with the Nuclear Waste Policy Act. I hope to hear in today's hearing that the NRC and DOE will be following through with their earlier statements and will use the available resources to move the review process as far along as possible. This should include plan to complete the safety evaluation reports, which this subcommittee is told would take an estimated 6 to 8 months to complete at a cost of $6.5 million. This should be all the more the case in light of the fact that the NRC currently has over $11 million and DOE has $16 million unobligated funds appropriated specifically for Yucca licensing activities. I also look forward to hearing how the NRC will be putting together the best staff possible to complete the SCRs, hopefully with assigning many of the same people who worked on the review process before it was halted prematurely. Finally, I believe the court's ruling gives this committee, the Energy Department, and NRC an opportunity to redouble our collective efforts in finding a final solution on this matter that can be based on consensus, science, and honor the $15 billion investment the American people has already made towards permanent SNF storage. Our country has a real serious impending issue at hand with regard to the storage and the disposal of nuclear waste and must be dealt with sooner than later. Currently, spent fuel and reprocessed waste is stored at nuclear plants in 77 sites scattered across the U.S., amounting to over 70,000 metric tons of spent nuclear fuel. Local communities are spending millions of dollars annually to ensure the safety and protection of our nuclear waste. Even with these current sites, we're still producing nuclear waste, and that waste will need to be stored for at least 1,000 years. If we do not take action by following the Circuit Court's decision or Congress finding a different path forward on this important issue, all of us, DOE, NRC, and Congress, will be letting down the very people we were sent here and endanger the health and safety of our communities. Again, thank Chair McFarland and Assistant Secretary Lyons for appearing today, and I look forward to your testimony. Again, thank the colleague for my time.
Gentleman yields back his time. Chair now recognizes the Chairman of the full committee, Mr. Upton, for 5 minutes.
Thank you, Mr. Chairman. You know, and I appreciate Chair McFarland and Dr. Lyons here today, this morning as well. As we know, the court recently ordered the NRC to proceed with the Yucca Mountain license review, and the first task in complying with the court's mandate and with the Nuclear Waste Policy Act is, in fact, to release the safety evaluation report. Fortunately, you do indeed have the resources to proceed with that release. Congress needs the opportunity to examine the NRC's long overdue, unredacted technical analysis, and the public who paid for it deserve to know the report's conclusions. During the last 3 years, the administration has been suppressing this document. Congress has been denied an informed discussion about the next steps. For quite some time, members on both sides of the aisle have been saying, with our words and with our votes, Yucca Mountain is, in fact, the law of the land. And a month ago, in August, the D.C. Circuit Court did agree and ordered that the NRC must proceed with the license review. The path forward is unmistakable. Compliance with the law is not optional. The framework of the Nuclear Waste Policy Act is simple. Electricity consumers pay for the cost of used fuel disposal as part of the cost of that electricity, and taxpayers pay for the disposal costs of the high-level waste legacy of the Cold War. But the reality of our current situation is, in fact, a lot different. With no progress on a permanent repository, both ratepayers and taxpayers continue to be charged, yet they aren't getting what they're paying for. DOE is spending the Nuclear Waste Fund money to shut down a licensing process which the court has said must proceed. NRC is spending resources to revise a waste confidence rule as a result of the repository program being shut down. And DOE is spending taxpayer money on a sidetrack effort to supplant Yucca Mountain. Unfortunately, the disjointed policies have resulted in higher costs. Moreover, electricity consumers are investing about $750 million each year for fuel disposal, but none of the money is currently being spent for that purpose in used fuel sites or sits at reactor sites, piling up even more cost to consumers. Resumption of the Yucca Mountain program remains the clearest, fastest, and most fiscally responsible way for the government to meet its obligations to provide disposal, to mitigate liability costs, and to reestablish a solid basis for the waste confidence rule. Not to mention, it is the law. Politics needs to be removed once and for all from this process. We've got to remember that while the administrations come and go, used fuel is here to stay. And after 3 decades, it's time that we finally achieve a permanent storage site. The NRC's completion of the SER is the necessary and long overdue next step. The issue has long enjoyed a history of bipartisanship, and we will work very hard to continue that tradition until the job gets done. And I yield back my time.
Gentleman yields back his time. Chair now recognizes the ranking member of the full committee, Mr. Waxman, for 5 minutes.
Thank you, Mr. Chairman. Our nuclear waste laws are not working. Instead of holding yet another hearing on Yucca Mountain, this committee should be working to reform them. In 1987, Congress designated Yucca Mountain in Nevada as the sole site to be considered for a permanent geologic repository for spent nuclear fuel and high-level radioactive waste. There was no Plan B. This decision to short-circuit the site selection process was widely viewed as political and provoked strong opposition in Nevada. 25 years later, it is clear that this top-down approach has broken down. President Obama wisely sought a new approach. He chartered a blue ribbon commission to develop a new strategy for managing the country's nuclear waste. Last year, we heard testimony from the co-chairs of this blue ribbon commission on the recommendations that resulted from their 2-year effort. In July, Secretary Moniz testified about DOE's strategy for implementing many of those recommendations. He argued that a consent-based approach to siting was essential, and his testimony raised a number of important policy questions, such as whether to create a new organization to manage the nuclear waste problem, how to use nuclear waste fees, and whether to construct one or more consolidated interim storage facilities in addition to one or more permanent geologic repositories. These are policy questions that require Congress to respond. Answering these questions requires an open mind and willingness to move past a narrow obsession with Yucca Mountain, but this committee seems fixated on Yucca Mountain. In August, the Court of Appeals issued a decision on the legality of the Nuclear Regulatory Commission's decision to suspend its review of DOE's application for a permanent repository at Yucca Mountain. The court ordered NRC to continue its review of the Yucca Mountain license application as long as it has any appropriated funds to do so. The problem with this decision is that NRC has just spent money so that $11 million in leftover funds is available for this purpose. This amount is not nearly enough to complete the review. In fact, the dissenting judge argued that the court was ordering NRC to, quote, do a useless thing, end quote, because most of the $11 million would be spent restarting the process and the rest spent putting the materials back into storage. The reality is that the court decision has not really changed anything. The decision does nothing to reduce the long-standing public opposition to Yucca Mountain. It does not establish a consent-based siting process or a new organization to focus on the waste problem, and it does not solve the tricky funding and appropriations issues to make sure that the funds put aside for constructing a repository or storage facility can actually be used for that purpose. A court decision was never going to resolve any of these issues. Today, the majority has summoned NRC and DOE for another meeting of the Yucca Mountain Fan Club. But the Commission hasn't had a chance to evaluate its options, develop its response to the court decisions, or even decide whether to appeal the decision. We should spend our witnesses a valuable time discussing other pressing nuclear safety issues. Yesterday, I sent a letter requesting a hearing on the troubling developments at the Fukushima plant in Japan. Radioactive water is leaking into the ground and the Pacific Ocean. Some hotspots have radiation levels high enough to deliver a lethal dose in 4 hours. The events in Japan deserve the subcommittee's attention, as do NRC's ongoing implementation of lessons learned from the Fukushima disaster and the closure of the San Onofre plant in California. Yucca Mountain has become a hopelessly divisive issue. The sooner we recognize this and start considering true reform, the sooner we will be able to fulfill our responsibility to craft a sustainable nuclear waste policy for the nation. Thank you, Mr. Chairman. Yield back.
Gentleman yields back his time. I'd now like to recognize myself for 5 minutes. I do have, oh, I'm sorry. I'm so excited about going to questions. So let me now recognize Madam Chairman from the Nuclear Regulatory Commission, Ms. McFarland, for 5 minutes for an opening statement.
Thank you, Chairman Shimkus. Good morning, Chairman Shimkus, Ranking Member Tonko, and distinguished members of the subcommittee. On behalf of the U.S. Nuclear Regulatory Commission, I appreciate the opportunity to appear before you to discuss the actions the NRC is taking to comply with the court's decision on Yucca Mountain licensing activities. I'm also pleased to appear with Assistant Secretary Lyons. The written testimony I've submitted for the record contains information about the NRC's response to the recent court decision on Yucca Mountain and the status of the NRC's technical and adjudicatory activities at the time they were suspended in 2011. As you are aware, on August 13th, a panel of the U.S. Court of Appeals for the D.C. Circuit directed the NRC to resume its review of the Department of Energy's application to construct a geologic repository for high-level nuclear waste at Yucca Mountain. On August 30th, the Commission issued an order requesting that all parties to the suspended adjudication provide their views within 30 days on how the NRC should continue with the licensing process. The Commission has also directed the NRC offices to gather pertinent budgeting information during this comment period. The Commission will make an objective, transparent, and collegial determination about the path forward based on the internal and external input we receive. Because the Commission has not yet reached its decision, it would be inappropriate for me to speculate about what the final direction would be. In March 2010, the DOE filed a motion to withdraw its license application, and at the end of fiscal year 2011, the NRC formally suspended its review. Between the time that the DOE submitted its application in 2008 and the suspension in 2011, the NRC staff conducted its regulatory review. Among other things, the staff's technical actions included work on the Safety Evaluation Report, otherwise known as the SER, the 5 volumes of which were left in various stages of completion. Separately, on the adjudicatory side, multiple parties filed petitions seeking a hearing in this licensing proceeding, and the Atomic Safety Licensing Board, or ASLB, granted most of the hearing requests. The focus of adjudicatory hearings is on whether the license applicant has demonstrated that the regulations have been met and the license should be issued. As the license applicant in this case, the DOE bears the burden of making this demonstration. When the adjudicatory proceeding was suspended, the ASLB closed out all activities associated with the hearing process on the DOE application. At that time, a total of 288 contentions had been pending resolution on the merits. To date, no evidentiary hearings have been held. In addition, the NRC had created a web-based licensing support network, otherwise known as the LSN. This was required by our regulations as a means for making all documents related to the adjudicatory proceedings available electronically to all participants. The NRC has preserved these records, but the LSN is no longer active. I recognize that the completion of the 5-volume SER is of particular interest. The NRC is confronted with challenges associated with reconstituting a multidisciplinary team to resume the licensing process. In addition, this milestone represents one, albeit important, element in the overall required licensing process. All of the issues raised before the ASLB must also be resolved. Finally, a completed, adjudicated environmental impact statement and supplement is also necessary for a license decision. As this committee is aware, the NRC does not have sufficient resources to complete all the remaining steps. As part of the normal license review process, the NRC would also need the DOE's participation as the applicant to address any issues the NRC identifies. I defer to DOE officials to address the Department's ability to do so. Chairman Shimkus, Ranking Member Tomko, and members of the subcommittee, the Commission will act expeditiously to direct the staff on how to expend the agency's remaining resources under the Nuclear Waste Fund. The Commission's recent order will help ensure that our decision has the full benefit of views submitted by various parties to the adjudicatory proceedings. We will provide additional information to the subcommittee through monthly reports as our decision process continues. I would be pleased now to respond to your questions.
Thank you, Madam Chair. Now I'd like to recognize Mr. Peter Lyons, Assistant Secretary for Nuclear Energy. Sir, you're recognized for 5 minutes.
Thank you, Chairman Shimkus, Ranking Member Tonko, and members of the subcommittee. I appreciate your invitation to testify at the subcommittee's hearing today. The administration takes seriously its obligations to manage and dispose of used nuclear fuel and high-level radioactive waste, as emphasized in the testimony of Secretary Moniz to this subcommittee just a few weeks ago. President Obama has made climate change mitigation a priority and set a goal of reducing emissions in the range of 17% below 2005 levels by 2020. He's emphasized the important role of nuclear power in his all-of-the-above clean energy strategy. Nuclear power remains the United States' single largest contributor, with more than 60% of non-greenhouse gas-emitting electric power generation, while it has reliably and economically contributed almost 20% of electrical generation in the United States over the past 2 decades. We believe that nuclear energy will continue to be an important part of the nation's low-carbon future. Finding a solution to managing and disposing of the nation's high-level radioactive waste and used nuclear fuel is a long-standing challenge. Such a solution, however, is necessary to assure the future viability of this important carbon-free energy supply and further strengthen America's standing as a global leader on issues of nuclear safety and nonproliferation. The administration's strategy for the management and disposal of used nuclear fuel and high-level radioactive waste provides a framework for the administration and Congress to continue to develop the path forward for disposal of nuclear waste, and provides near-term actions to be implemented by the Department of Energy pending enactment of new legislation. We're facing a unique opportunity to address the needs at the back end of the nuclear fuel cycle by setting it on a sustainable path, providing the flexibility needed to engage potential host communities and anticipate advancements in technology development. The administration is ready and willing to engage with both chambers of Congress to move forward. Since Secretary Moniz testified before this subcommittee, the U.S. Court of Appeals for the D.C. Circuit has issued a writ of mandamus ordering the NRC to resume its review of the Yucca Mountain license application. On August 30th, the NRC issued an order inviting all participants in the license proceeding to provide by September 30th their views as to how the agency should proceed. The Department is carefully considering how to respond to this order. As we have long made clear, however, the Department will comply with NRC or judicial orders that are directed to DOE, subject, of course, to the availability of appropriated funds. And as recently reported to the subcommittee, the Department currently has approximately $16 million in unobligated funds originally appropriated for Yucca Mountain licensing activities, and in addition, the Department has approximately $30 million in obligated uncosted balances already committed on existing contracts. As we've said consistently, any workable solution for the final disposition of used fuel and nuclear waste must be based not only on sound science, but also on achieving public acceptance at the local, state, and tribal levels. When this administration took office, the timeline for opening Yucca Mountain had already been pushed back by 2 decades with no end in sight. It was clear that stalemate could continue indefinitely. Rather than continuing to spend billions of dollars more on a project that faces such strong opposition, the administration believes a pathway similar to that the Blue Ribbon Commission laid out, a consent-based solution, is one that meets the country's national and energy security needs and has the potential to gain the necessary public acceptance. The administration looks forward to working with this committee and other members of Congress on crafting a path forward for used nuclear fuel and high-level waste management and disposal. This progress is critical to assure that the benefits of nuclear power are available to current and future generations. And I'll be pleased to answer questions that you folks may have.
Thank you. Now, before I start my questions, Madam Chairman, we're going to hand you 4 documents that I'll be referring to in my questions, and I'd like to recognize myself for 5 minutes. Madam Chairman, have you read the June 6, 2011 NRC Inspector General's report that I referred to in my opening statement?
Sorry, can you repeat the question?
Have you read the June 6, it's right in front of you, have you ever read that June 6, 2011 NRC Inspector General's report that I referred to in my opening statement? And if you would, could you please read the highlighted excerpt from the IG's report on page 28 regarding comment by the NRC's Assistant General Counsel?
Sure. You want me to read this?
Please.
Sure. And for the record, I have not read this before.
Okay. Well, it will be then instructional to do so.
Good. She said that as of, I assume, was the
Assistant General Counsel.
She said that as of July 15, 2010, Volume 3 had been provided to the NMSS Director and was reported to be substantially complete. However, the document was undergoing additional editing and formatting, including a final quality control check to assure appropriate nomenclature, proper numbering, and sequencing, and other minor administrative changes that may be necessary to ensure completeness and accuracy.
Thank you. So Volume 3 was substantially complete, except for editing and formatting. In fact, when Chairman Yasko directed the staff to stop their work on October 4th, 2010, the NRC was within about 3 months of issuing Volume 4, within 5 months of issuing Volume 2, and just 6 months for releasing Volume 5. And you kind of mentioned that in your opening statement at various stages. According to the NRC's internal schedule, which was this committee examined in our June 2011 hearing with the IG. Now I want to turn your attention to a commission memorandum and order labeled CL10914, which you also have with you, which states, and I'll quote it, "Today we respond to appeals of the Construction Authorization Board's first pre-hearing conference order."
I don't have it, I'm afraid.
Oh, do we want to? Okay, I'm sorry, you don't have that. We can get it to you, but now according to the 10 Code of Federal Regulations Part 2 Appendix D, which is the schedule for NRC to conduct the construction authorization proceeding, 150 days after the application was docketed, the Commission was supposed to rule on appeals for the first pre-hearing conference order, which we know the Commission did based upon CLI 0914. Chairman McFarland, would you please read the next item, which is highlighted on the schedule, which is the next step to take?
Certainly, yeah. So this is Appendix D to Part 2 of the 10 CFR. And this is the schedule for proceeding with, this is the process laid out in the regulation.
Transparently on your website for everyone to see.
So on day 548, the action is that the Nuclear Regulatory Commission staff issues the safety evaluation report.
Great, thank you. This committee has previously established that NRC has enough funding to complete and release the SER. In our February 28, 2013, so we're not going to allow you to commingle this financial debate based upon other activities. Our point is, confirmed in testimony, that you have the funds available to finish the SER. In our February 28, 2013 hearing, you agreed that if the court required NRC to move forward, you would do so. As you have just read, releasing the SER is the very next action for the NRC to take. Given that the NRC was required to begin complying with the writ of mandamus last week on September 3rd, is the NRC currently taking any action to complete the remaining SER volumes?
We have taken action already. We are the Commission is operating expeditiously on this matter. We issued an order that requested
but what have you done other than asking for other people to weigh in? What have you done in this month to start moving the SER forward?
Thank you for the question. We have asked our staff to provide us with budget information. We have to understand the lay of the land in terms of the budget.
And you will be providing us monthly updates.
And we will provide
And we will ask you to provide monthly updates on exactly what we're doing to move the SER forward.
We will provide you monthly updates on where we're going and what we're doing. And I believe the first monthly update will begin in the middle of October.
And my last question, the quote-unquote transparency page of the NRC website states, the U.S. Nuclear Regulatory Commission has a long-standing practice of conducting its regulatory responsibilities in an open and transparent manner. In that way, the NRC keeps the public informed of the agency's regulatory licensing and oversight activities, which you stated earlier. Dr. McFarland, especially in light of the NRC's commitment to transparency, you don't really see a scenario where the NRC will decide not to release the safety evaluation report, do you?
We are still deliberating on that, so I can't say.
So you might find a way in which you might not.
I can't say one way or the other, but I certainly
But the court has said you must, and we know you have the money.
The court has said we must proceed with the licensing.
And you've already testified that you have the money.
We
for the safety evaluation report.
We testified. I believe it was last.
You testified.
Yes, that
you would comply with the law.
That I certainly did.
And you would submit the safety evaluation report, and you also testified that we have the money to do so. So the question is, you don't see any scenario that you would not do this.
We are still taking views from the parties.
So you do see a scenario where you may not do this?
We are still taking views from the parties, and we will.
Madam McFarland, are you going to comply with the law based upon your previous statements and that the fact that you have money available to do so?
Of course, we will comply with the law.
Thank you very much. I'd like to now recognize Mr. Tonko for 5 minutes.
Thank you, Chair Shimkus. I would like to thank Chair McFarland and Dr. Lyons for appearing before the subcommittee today. But I regret that we didn't wait a few weeks to let NRC and DOE take some time to figure out a path forward in light of the Court of Appeals decision. I therefore ask about the status of the proceedings so that members will have a better sense of what questions you are able to answer at this time. On August 30th, NRC issued an order inviting all participants in the Yucca Mountain proceeding to provide their views as to how the Commission should continue with the licensing process. This is an opportunity for both the opponents and supporters of Yucca Mountain to make suggestions to the Commission about how they should proceed. The deadline for providing their views, I believe, is September 30th. So, Chair McFarland, are you able to testify today about the likely outcome of that stakeholder process?
No.
And Dr. Lyons, has DOE responded to this order yet?
Excuse me. No, Mr. Tonko.
Is your mic on or is it pulled close enough to you?
Sorry. Is this better?
Yes, sir.
Okay. Mr. Tonko, we are awaiting action by the NRC with regard to their decision before we decide how to proceed with the licensing effort.
Okay, thank you. The Commission also directed the NRC staff to gather pertinent information, budget information, during this 30-day comment period. There's only $11 million available, so you will need to know what the price tag would be for the range of possible activities. Chair McFarland, are you able to give definitive estimates today about the cost of various options without the budget information that is currently being developed?
No, I am not. That's why we asked the staff to collect the information for us.
Thank you. And how long after that September 30th deadline will it take for NRC to compile all of the views and produce a plan for responding to that court decision?
I am not certain at this point in time, but we will endeavor to work as expeditiously as possible.
I thank you for that. It makes sense for NRC to await the outcome of this public comment process before reaching conclusions about the very best way to spend the agency's limited resources. You should get the facts and do the stakeholder outreach before making decisions. So the story of the Yucca Mountain Repository is a story of one group of stakeholders believing that they could ignore the concerns of another group of stakeholders. That's a mistake we do not want to repeat. There is the separate question of whether the Court of Appeals decision will be appealed. Chairman McFarland, has the window for NRC to appeal the court's decision closed?
Sorry, can you repeat the question?
Sure. Has the window for NRC to appeal the court's decision closed?
No, it has not.
Okay. And will you be able to share NRC's plans to appeal or to not appeal the decision with us today?
No, I cannot.
Other parties may also choose to appeal. Is that correct?
That is correct. Other parties may choose to appeal.
So we don't even know whether the Court of Appeals decision will be the final answer in this case. In many ways, the Department of Energy's planning is contingent on NRC determining its next step. Dr. Lyons, what actions can DOE take with regard to the license application before NRC determines how to proceed?
I'm sorry, could you repeat that question?
Sure.
I'm not
What actions can DOE take with regard to the license application before NRC determines how to proceed?
We really are in a position where we must await the actions by the NRC, understand their path forward and what may be required from the Department of Energy, and only then can I answer that question. It would be premature now.
Thank you. And Chairman McFarland, would you have been in a better position to answer the subcommittee's questions about implementation of the court's order in a few weeks?
In a few weeks, yes.
And Dr. Lyons, what about you?
Yes, once we understand the path forward identified by the NRC, we can then evaluate how we will respond.
Thank you. Well, I hope that members of the subcommittee will be mindful of the position we have placed the witnesses in by insisting that they testify today rather than in a few weeks. Members want to know what the plan is for responding to the court's order, but the plan hasn't been developed yet. The court issued its order less than 2 weeks ago, and the agencies need to examine the options and the cost of those options to see what can be done with the limited funds available. These are questions that will be answered in due time, I am convinced. Unfortunately, it seems obvious that we won't get those answers today. And with that, I'll yield back, Mr. Chair.
Gentleman yields back his time. I would just remind my colleague that they've had 30 days since the court order, and we can always have them come back. So I'm sure they'd be happy to do so. So
I'm talking about valuable use of their time in a way that brings into order, working order, all of the requirements that have been.
And I'm talking about oversight by the legislative branch over the executive branch and independent agencies. I yield now 5 minutes to Mr. Gingrey for his statement.
I thank the chairman for yielding. I agree with him completely. The importance of the oversight of the legislative branch over the executive branch, and as he just pointed out, you've had 30 days, and why should we waste additional time? Therefore, the timeliness of this hearing, and I do appreciate both of you being here. I strongly agree that the NRC should immediately work to issue the safety evaluation report. The cost of completing and publicly releasing the SER has been estimated to be $6.5 million. That seems a little high to me, but as I understand it, the safety evaluation report is comprised of 5 volumes. Volume 1 was completed and released, so that means there are 4 volumes left, as pointed out by Chairman Shimkus. Volume 3 was reportedly substantially complete. On page 27 of the Inspector General's June 6th report, the IG reported that the NMSS director believed that minimal resources were needed to complete the review process and issue Volume 3. She also commented that by September the 30th, 2010, NRC had all the information it needed from DOE to complete the SER. To Chairman McFarland, please answer yes or no, Chairman McFarland. So Volume 3 is substantially complete and requires minimal resources, correct? Yes or no?
I have not seen Volume 3, and I understand it is in some stage of completion, but I do not know the entire stage of completion. I do not know how many resources it will take to complete. That's why we have asked the staff to go and make some efforts.
Yes, but therefore it shouldn't take long to issue that one. Is that also correct?
It depends largely on what the staff says it needs. I think we need to understand something to begin with here, that the staff that we had originally assigned to work on the safety evaluation report have since been reassigned. A number of them have retired. And so it will take some time to reassemble this group, being mindful that there are a number of staff who are working now on mission critical issues, and we need to be careful that we don't
it sounds
lose
like,
that
Madam Chairman, it sounds like what you're saying is it depends heavily on whether they're go-getters or foot-draggers, these replacement team that you're talking about. Dr. Lyons, yes or no? Is it your understanding that completing the SER doesn't require any additional information by the Department of Energy, thereby not costing the Department of Energy, DOE, any additional resources? Yes or no?
I can't respond to that, sir, because it will depend on whether the NRC asks us additional questions if they were to choose to move in that direction. I haven't seen the SER either, and I have no idea what the NRC may request of us.
Well, during the June 14, 2011 hearing, this committee examined an NRC internal schedule for releasing the SER volumes when former Chairman Yaxco shut down the staff's review October the 4th, 2010. Volume 2 was about 5 months from being published. Now, this was 2010. Volume 4 was a little over 3 months from being published, and Volume 5 was less than 6 months from being published. That's a fact. Chairman McFarland, given these volumes were nearly ready and do not require any input from DOE, Why should it cost $6.5 million to complete and publish them?
I don't know how much it will cost to complete and publish these. That's why we have asked the staff to give us estimates of what they need in terms of resources and staff.
Well, do you know this, Dr. McFarland? How much money will be spent seeking comments from the parties?
A de minimis amount.
Does that money come from the Nuclear Waste Fund?
I'm going to take that one for the record just to be sure.
If you'll get back with me on that, I
Certainly.
would greatly appreciate it. And lastly, Dr. McFarland, will you commit to have the Commission approve all NWF expenditures, Nuclear Waste Fund expenditures?
Have the Commission,
Will you commit to have the Commission approve all Nuclear Waste Fund expenditures?
I'm going to have to take that one for the record too. I need to find out what the required process is in the regulations and in the law.
Well, I know you can't get that to me in 2 seconds, but I would very much appreciate that information.
Absolutely.
I yield back.
Gentleman yields back to time. Chair now recognizes Chairman Emeritus Mr. Dingle for 5 minutes.
Chairman, I commend you for the hearing. I thank you for the recognition. My questions will require mostly yes or no answers. And I want to begin by saying we have a fine mess on our hands. Taxpayers are paying, ratepayers are paying, money is being dissipated, work that should be done is not being done. Madam Chairman, I don't blame you for this. This antedates your work, and a lot of it originates in a place in the United States Senate. In any event, according to a recent ruling by the D.C. Circuit Court, testimony you've given this subcommittee, NRC has approximately $11 million in funding for the licensing review process. Since you last testified before this subcommittee in February, has the NRC spent any of these funds, yes or no?
Since the court decision, the NRC spent a de minimis amount. We're now focused on going forward and determining how to spend the remaining amount.
Would you submit to us a statement of how much has been spent and how much remains in that fund? Now, Madam Chairman, I understand NRC has an open comment period soliciting feedback on how the Commission should move forward in the light of the D.C. Court's recent decision. One major step in the process is completion of the safety evaluation reports. One of the 5 volumes has already been completed. It's my understanding the technological evaluation reports were completed for 3 of the 4 remaining volumes. Does NRC have staff in place that is qualified to take these technical evaluations and complete the safety evaluations with the appropriate recommendations, yes or no?
We don't have them all in place now. We are asking the staff to get back to us about staffing and resource needs.
Would you submit to us, please, a statement of the status of those matters for the record? If NRC were only to focus on completion of the safety evaluation reports, do you believe you have enough funds to complete the report, the work on the reports? Will you please answer yes or no?
As referenced earlier, in previous testimony, we said that we had $6.5 million, or it would cost $6.5 million to complete the SER, but we've asked our staff to update that number.
Would you submit us a statement of the status of those funds, please? Now, Mr. Lyons, is DOE collecting fees into the Nuclear Waste Fund, yes or no?
Yes, the funds continue to be.
Thank you. The D.C. Circuit Court decision in 2012 ordered DOE to reevaluate the fee assessment. Since Yucca Mountain facility has not moved forward in recent years, and there is still no statutorily alternative site for permanent high-level waste repository, has DOE considered whether it should continue to assess the fee? Please answer yes or no.
Mr. Dingle, as Secretary Moniz discussed when he was with this subcommittee, the fees continue to be collected because they reference a service of disposal of the used fuel.
Yes or no, sir? My time is very limited. Please, yes or no? To the question, yes or no?
Again,
Okay.
we
now,
are.
would you please submit additional additional information on that matter for purposes of the record. Now, because the federal government has not upheld its responsibility to provide a permanent high-level nuclear waste repository, it is my understanding that owners of nuclear facilities are suing the federal government for compensation to store waste on sites at locations across the country. According to the February 2012 report by CRS, there's been over $2 billion in awards and settlements as a result of these claims. These payments come from the judgment fund funded by taxpayers' dollars. The Department of Justice has spent approximately $200 million defending the government against these claims. Now, Madam Chairman, I urge NRC to focus on the completion of the safety evaluation reports. Should the reports determine that the Yucca Mountain facility is appropriate, hopefully opponents will allow the process to move forward. Should reports deem the Yucca Mountain unsafe, I think this committee and I are prepared to work with all of our colleagues to amend the Nuclear Waste Policy Act and to find a viable path forward in order to deal with the safe disposition of nuclear waste. We have to find a way forward, and I believe that the completion of the safety evaluation report will significantly help us follow the path forward. Will you please comment on that with a yes or no? Do you agree or not?
Completion
Just
of,
yes or no.
completion of the safety evaluation report is one step in the overall process, and we are already receiving
Madam Chairman, I'm going to ask you to just yes or no, and then I'm going to ask you to submit a further statement for the record on the matter.
It's a complex situation. I can't answer yes or no.
All right. Well, this demonstrates what a magnificent mess we have here. And I don't blame you, Madam Chairman, but you've sure got to get busy to get it fixed. Thank you, Mr. Chairman.
And I thank my colleague. Chair now recognizes the gentleman from Kentucky, Mr. Whitfield, for 5 minutes.
Well, Chairman Shimkus, I want to thank you very much for having this important hearing. You know, in my humble opinion, the Obama administration has really established a pattern of disregarding laws that they do not agree with. Now, in 1987, Congress passed the act identifying Yucca Mountain as a primary national repository site. Prior to that, DOE looked at 9 sites, but in '87, Congress acted. And in this decision, I'd like to just read some excerpts from this decision that was just issued. The Nuclear Regulatory Commission has continued to violate the law governing the Yucca Mountain licensing process. The statutory deadline for the Commission to complete the licensing process and approve or disapprove the Department of Energy's application has long since passed. Yet the Commission still has not issued the decision required by statute. Indeed, by its own admission, the Commission has no current intention of complying with the law. Rather, the Commission has simply shut down the review and consideration of the process. Now, from a taxpayer standpoint, $15 billion has been spent on Yucca Mountain. And in 1983, the government entered into contracts with the 104 nuclear power plants, roughly, that the government would take possession of that material, that waste material, in 1998. That time has come and gone, and the federal government was sued because they did not take possession because Yucca Mountain was not completed. And so in addition to the $15 billion spent on Yucca Mountain, we now have judgments that by 2020 is supposed to equal $19 billion because the government cannot meet its contractual obligation. And so here the taxpayers are with a $17 trillion federal debt, $34 billion spent on Yucca Mountain, and the court's saying that the Nuclear Regulatory Commission, which you are now responsible for, Chairman McFarland, you've been there for a year and a half, and I don't blame you for this because you did not take the action that precipitated this lawsuit. But with all of this money spent, and with a clear violation of the federal law, I would hope that you and Mr. Lyons has been at the Department of Energy since the beginning of the Obama administration, I believe. I hope that you will do everything possible to expedite this, not try to rewrite the law, not try to change other people's opinion, but make a decision based on the safety issues. And even the court says there's $11 million available right now to start this process. And so can you commit to the committee that you intend to move forward to try to obey the law?
Certainly. We commit to moving as expeditiously as possible.
And I hope that you'll direct your staff to do the same.
And we have already done so.
Do you have any comments, Mr. Lyons?
I would only comment that the dollar values that you cite are precisely the reason why the administration feels strongly that it's important that we move forward on a workable solution as opposed to spending still more money on an unworkable
Well, I mean,
solution.
it's a federal law right now that Yucca Mountain is the designated site. So I don't think that you all have a right to go around and, I mean, I know what the Blue Ribbon Commission said. They want to just start all over again, but we have a federal law in the books. The courts have said that it needs to be enforced, and the court has said that the Nuclear Regulatory Commission is violating the law. So with all due respect to the great work that you all do, the great responsibility that you have, I do think you also have a responsibility to be leaders and enforce the law and try to protect the taxpayers' money. And the President frequently talks about an all-of-the-above policy. I support an all-of-the-above energy policy. And yet what he's doing in the area of nuclear would indicate that he's not really committed to that. And we know that you cannot build a new coal-powered plant in America, the only country in the world where you cannot do so. So how can he say that he's for an all-of-the-above energy policy? My time has expired.
Gentleman's time has expired. Chair now recognizes the ranking member of the full committee, Mr. Waxman, for 5 minutes.
Thank you very much, Mr. Chairman. I'd like to ask Chairwoman, Chair McFarland? Chairman McFarland, you've testified today that the NRC is still formulating its response to the recent court ruling and that it's hard to discuss a plan that isn't yet created. Therefore, before turning to Yucca Mountain, I want to ask you and take this opportunity to inquire about some issues that are important to the people of California, about recent events at the damaged Fukushima nuclear power plant in Japan. Over the last several months, news reports have painted a troubling picture of the situation at Fukushima. The Tokyo Electric Power Company, TEPCO, announced that pits and tanks holding vast amounts of radioactive wastewater had begun leaking. Contaminated water is flowing into the Pacific Ocean at the rate of about 300 tons per day. At the same time, Japanese officials have said that TEPCO may need to release contaminated water from the storage tanks into the ocean. Some news reports have raised concerns about whether radiation entering the Pacific Ocean from Fukushima could eventually reach the shoreline of the United States and its territories. Chairman McFarland, what impact, if any, will the contaminated water from Fukushima have on America's West Coast? What assurances can I give my constituents at this time?
Thanks for the question. This is an important issue, and I know it's been in the news a lot lately, so I know it's of concern to many people. Contaminated water has essentially, in my understanding, been leaking from the Fukushima site since the beginning of the accident. One thing people should keep in mind is that the largest releases of contamination of radioactive materials were 2.5 years ago, and they were significantly larger than anything that's being released on a daily basis now. But the good news is the Pacific Ocean is very large, and any radionuclides that get into the Pacific Ocean near Fukushima will be diluted by many thousands of times by the time they get anywhere near the west coast of the United States. And so in the end, there will be very little harm or negligible harm to the west coast of the United States. So people in
Well,
the
that's
U.S.
comforting.
can remain assured that they will be okay.
That's comforting. It appears that TEPCO did not adequately anticipate the challenges of managing vast amounts of radioactive wastewater over a long period of time. This raises questions about additional lessons that we can learn from the Japanese experience. What is NRC's Fukushima Task Force doing to review the wastewater challenges at the Fukushima plant and apply any lessons learned to U.S. facilities?
Well, we are certainly, and we have been taking lessons through the entire accident and now as well. And my understanding is that some of our research folks are looking into the situation of dealing with large volumes of contaminated water after an accident now.
So you're continuing to prioritize preventing an accident at U.S. facilities, but NRC has tasked some researchers with the question of how better to handle large volumes of radioactive water, wastewater. Is that your position?
Yes, we're.
Okay. Thank you. Yesterday, Ranking Member Tonko and I sent a letter to Chairman Upton asking that the committee schedule a hearing to review the recent events at Fukushima and the lessons we can learn from them. And I'm hopeful we can agree that this is a topic worthy of bipartisan examination. Turning back to Yucca Mountain, the majority called this hearing to examine the recent court decisions requiring NRC to restart the license review process, but the court didn't resolve the most fundamental outstanding question about the future of this possible waste repository. Dr. Lyons, did the court decision alter the state of Nevada's long-standing opposition to the project?
Well, I'm not sure I'm the best equipped to answer that, sir, but not to my knowledge.
Okay. The President's Blue Ribbon Commission recommended that Congress create a new organization devoted entirely to managing the nuclear waste problem. Did the court decision determine what that organization should look like?
The court decision did not address that, sir.
We also need to fix several funding and appropriations problems to make sure that the funds put aside for constructing a repository or storage facility can actually be used for that purpose. Did the court resolve those issues?
No, sir.
The court decision doesn't resolve any of the major policy questions facing this committee. We need to heed the advice of the Blue Ribbon Commission, adopt a new consent-based approach to tackling the nation's nuclear waste problem. Nothing in the court decision changes the fact that Congress needs to act in a bipartisan manner to accomplish this. Thank you, Mr. Chairman.
Gentleman's time expired. Chair now recognizes the gentleman from Ohio, Mr. Latta, for 5 minutes.
Thank you, Mr. Chairman, and thank you very much to our witnesses for being with us today. I greatly appreciate hearing your testimony today. Chairman McFarland, if I could pose my first question to you, and if I may, I'm going to have to read through a little bit here. But according on April 11th, 2011, from an order from the Nuclear Regulatory Commission, the Atomic Safety and Licensing Board, it stated that in order to fulfill the responsibility to preserve the document discovery materials residing on the LSN, a system mandated by 10 CFR Part 2, Subpart J, etc., said the board directs pursuant to its authority under the 10 CFR that each party shall take the following actions. Preserve all LSN documents in PDF format, submit its LSN document collection together with the associated biographic files to the NRC Office of Secretary on optical storage media specified in guidance for electronic submissions to the Commission for the inclusion into the docket. And then also for large collections taking more than a month to complete the PDF, to submit those documents converted on another a little bit later. But it says that once received, the Secretary shall install the documents and associated biographic information into a separate LSN docket library on Atoms for public access via www.nrc.gov. Then a little later, and at another date, there's an order, or it states that on May the 12th, in an oral argument from the Aiken County case, this is on May the 12th, 2012, one of the attorneys for the commission stated In other words, we would presuming that we would order us to take back up. We may not activate the LSN. We may simply treat the case as a larger paper case. I guess, Chairman McFarland, my question then is, if I understand this correctly, the LSN documents are available to all parties and the public at this time, and hence, the LSN would not need to be immediately reconstituted prior to the resumption of the proceeding. Is that correct?
The LSN documents are not available at this point in time. They are in a safe, from my understanding, and so the LSN network would have to be reconstituted as part of moving forward. That's required in our regulations.
Okay, but could you explain that difference then from this order from April the 11th, 2011?
I'm going to have to take that for the record so I can see that order and give you a proper
okay,
answer.
because I tell you what, we'll get this to you because we need to get that answered, because it's saying here that that once received, and then when they're talking about the NRC Office of the Secretary shall install the documents and associated biographic information into a separate LSN docket library of atoms for public access via www.nrc.gov.
Yeah.
So we'll get this to you if we get an answer to that, please.
Absolutely.
And right now, with DOE's and NRC's actions shut down the Yucca Mountain program, and the license review triggered the two mandamus cases and the waste competence case for the D.C. Circuit Court. Dr. Lyons, if I could ask, since DOE has really caused the mess that is on out there by attempting to withdraw the license, and the court has now corrected it, will you commit to this committee that DOE will not attempt to slow or obstruct the resumption or pace of the licensing review?
At this point, I can commit that we will continue to evaluate the NRC's decision and formulate a path forward. And I'm not sure I heard all of your
Okay,
questions.
but the question is, when you say that you're going to commit to go forward, but you're not going to be slowing the process down to get to this decision, are you? Where we're supposed to be?
We have committed to respond to NRC requests within available appropriations.
Well, we want to make sure that, because there's a lot of money that's being spent out there, and it's taxpayers' dollars, and we want to make sure that this is not slowed or obstructed, and we want to make sure that the pace is going on the licensing review. So that's one of the things we'd like to see that's committed from DOE. And, Mr. Chairman, I see my time's expired, and I yield back the balance of my time.
Gentleman yields back his time. Chair now recognizes the gentleman from Texas, Mr. Green, for 5 minutes.
Chair McFarland, in the record of the hearing before the subcommittee on February the 28th, you and your fellow commissioners committed to honor a decision of the Court of Appeals for the D.C. Circuit Court concerning resumption of the Yucca Mountain licensing process. Recognizing that commitment, the court's statement regarding the need to comply with Congress' direction on the Nuclear Waste Policy Act, do you believe the agency should appeal the decision?
I can't say at this time the period for seeking review hasn't expired, so it wouldn't be appropriate for me to comment.
Besides the August 30th commission order, what actions have been taken so far by the agency to respond to the court's decision?
We have issued an order asking the parties and participants to comment on how to proceed, and we have also requested from the staff budget information on how much it would cost to move forward, to expend the $11 million.
The safety evaluation reports will inform the public and Congress of the results of the NRC's extensive review of the license application. A number of entities have recommended that completion and publication of the SARE should be the NRC's first priority. What is your view?
It is a significant part of the process that we talked about earlier. That's set out in Appendix D, but it certainly doesn't constitute the entire licensing decision. The SER will not, in and of itself, provide a licensing decision. We have to also complete the adjudicatory hearing, and the Commission has to hear contested and uncontested issues.
Okay. In my opening statement, I was concerned about the funding. Parties in the Yucca Mountain licensing procedures have suggested the NRC reconstitute the hearing boards and restore the licensing support network as a first priority. In light of the fact that there only remains 11.1 million available in NRC's review of the Yucca Mountain application, do you believe that implementing these suggestions would deplete those available funds without appreciably advancing the agency's review and adjudication of the application?
It would be inappropriate for me to comment now because we're still collecting information on this.
Okay. Could you, when the time comes, I know if we could get our committee.
Certainly, the Commission will make all its decisions public.
Previously, NRC estimated 6 to 8 months was needed to complete all the volumes of the SCR at the cost of $6.5 million. The budget is within the appropriated and unobligated funds now available to the Commission. What steps have you taken to evaluate the basis for the $6.5 million estimate? Do you believe that $6.5 million is accurate?
We've asked the staff to go back and give us an updated estimate of that, and so we're waiting to see what the staff says.
Are there any other efficiencies that the agency can adopt to reduce the cost of completing the SERs without sacrificing their quality?
Well, we're in the process of collecting all that information now, so we'll have a better answer for you in some time.
What schedule do you believe is reasonable for the NRC to complete and publish the SERs?
Again, that's information that we're collecting right now. I can't comment.
Given the importance of the SERs as part of the record, the NRC's adjudicatory proceedings, would you agree that the resumption of the hearing should occur only after the completion of the SCRs?
Again, we have to hear from all the parties and participants to the proceeding, and we have to get information from the staff on resources required.
The Yucca Mountain license application utilized a total system performance assessment as a methodology to assess the long-term performance of the repository's acceptability. Chairman Farland, before you became a member of the Commission, you were critical of that methodology. Can you assure the public that you can objectively evaluate the license application and include its reliance on the TPSA?
Absolutely. I have an open mind on this matter, on the Yucca Mountain licensing matter, and I will maintain an open mind on it.
When do you expect to be able to issue an order or a staff requirements memorandum announcing the Commission's response to the Court's decision?
Well, we already did issue one order. Okay. Asking the parties to comment and requesting the staff to collect budget information. And then the next steps, I can't tell you exactly when we'll do it, but we're working as expeditiously as possible.
So there's no time frame on the staff reporting back?
The staff will report back, and the parties will comment by the end of September. September 30th, I believe, is the close date for that information.
Okay, Mr. Chairman, thank you. Obviously, we need some more hearings.
Thank you. And now the chair now recognizes gentleman from West Virginia, Mr. McKinley, for 5 minutes.
Thank you, Mr. Chairman. Several questions. One is I just was verifying the quote that was given on August 21st. It was kind of a revealing quote from Senator Reid when the question was raised to him with a news broadcast in Nevada about the thoughts of the court decision. His response was, as a result of political compromise, we put some really bad judges on the circuit court, and they produced a 2-to-1 decision requiring the Nuclear Regulatory Commission to license Yucca Mountain. Their opinion means nothing. Yucca Mountain is dead. It's padlocked. Nothing's going to happen there. Now, we've had 3 votes in Congress over the last year on a vote of 4-to-1 ratio saying we want something to happen. Was Harry Reid correct that nothing is going to happen? It means nothing for the vote of a court and the vote of Congress to take this action? Either one of you.
I can't comment on the senator's statement.
You comment your opinion. Was he correct? That's what I'm just asking. Was he correct?
I can't comment on the senator's statement.
You don't know whether he's correct?
I can't comment on the senator's statement.
Yeah, I hear you. Mr. Lyon?
Well,
was he correct? Yes or no?
I certainly can't comment on what the senator said. That's simply not appropriate. However, the court decision stands, And
Well,
we are
if-
awaiting
if
the
either of
NRC's
you
review
can't-
of the court decision.
If you can't, I know what your answer is on the thing, but I was just curious to see if you would say it aloud. But let's go back to this. Under the regulations, there was apparently an ability that the other states could override Nevada, or the Congress could override Nevada. So I'm just curious, when they listened to the state of Nevada, and this was a decision made and it's been endorsed now by enough congressional votes that there's support, did you go back to the other 34 states and ask them their opinion before? Mr. Lyon?
I have to confess that I'm not sure I'm following the line of your questioning, sir.
Well, there is the issue comes down to whether or not the definition of public support. If the public support of Nevada overrides I believe there are 34 other states that have spent nuclear fuel rods. Did you go back and ask them whether or not they concurred with this decision to stop the movement in Yucca Mountain? I think the answer is yes or no. Did you go to the other 34 states and ask them for their input?
The administration has stated on many occasions that a workable solution
So the
is
answer
a path
is no.
forward.
I'm going to assume, unless you say otherwise, the answer is no. You only went to Nevada with that. Can you tell me by what authority, if the Congress has acted this way, what authority do you have just to deem away an act of Congress that we're not going to do this?
Yeah,
They were not going to proceed, that the court had to step in and make you do it.
If the gentleman would yield, and to the members of the panel, you better take the question seriously, because he's asking a question, why didn't you comply with the law? That's the basic question. If you're confused about what Mr. McKinley is asking, he's asking why the NRC walked away without a public hearing and not complied with the law, and he's asking you, from the DOE perspective, why did the administration not comply with the law? And I think that's a very serious charge.
Let me say from the NRC's perspective that we, of course, intend to follow the law. We are now following the law. And we are moving forward. We are forward-focused on this. And in terms of your question of did you ask other states, we have asked all parties to the legal proceeding and participants to comment now, moving forward.
So the other states they've agreed?
It's up to them whether they comment.
Okay, just one in closing, in the few seconds I have left on it. There was testimony earlier about in Michigan and elsewhere, but at least in Michigan, it was some $600 million has been spent in the Yucca Mountain project out there. Are they going to be, if we don't advance this, if it doesn't, are they going to be reimbursed, or what did the state of Michigan get for the $600 million that the taxpayers spent at Yucca Mountain? What did they get for that?
That is, we as the NRC, our job is to ensure that a repository application and the repository itself would be safe and operate safely. That's our job. So in terms of policy questions associated with the Nuclear Waste Fund, that's something that I defer to the Department, the Administration, and the Congress.
Okay, I'm sorry.
Gentleman's time's expired. Chair, now recognize the gentleman from California, Mr. McNerney, for 5 minutes.
Well, thank you, Mr. Chairman. Chairman McFarland, it seems to me that the hearing we're holding here this morning is premature. We should be holding this hearing in 2 weeks or a month later, that you would be able to answer a lot of the questions that have been asked this morning more satisfactorily. Would you agree with that?
I think in a number of weeks or a month or two, we will certainly be able to have more satisfying answers for you.
Would you be able to produce a more concrete answer in terms of when you would be ready to answer the questions that have been asked this morning?
In a number of weeks or a month, certainly after we have been able to, after the time has expired for parties to comment and the staff to get back to us after the end of September, and after we have a little bit of time to sift through those, we will have a much better idea of what the plan is to move forward.
Would the gentleman yield, just not to take away from your time, but they will be coming, the full commission will be coming back this fall, and that'll give us an opportunity also to fully vet this.
End of October, we'll be back.
Thank you. Well, focusing funds of the safety evaluation report on the safety evaluation report is presumably one of the options that the Commission will be looking at, but the safety report is just one many steps needed. You've mentioned a couple of these. There will need to be an environmental impact statement would need to be supplemented. More than 300 claims would have to be conducted, adjudicated, more than 100 depositions taken, and then there would need to be evidentiary hearings, and then the final decision would be made by the Commission. Is that about right?
There's some other steps in there too. The licensing support network that's gotten some discussion this morning would have to be put back, and there's some other issues as well, that the environmental impact statement would have to be completed, and the supplement would have to be completed as well.
Dr. Lyons, even if the license were issued sometime in the future, there would need to be more steps that would have to happen before the repository would be operational. For example, the state of Nevada is strongly opposed to the project, and they would need to issue a number of permits. Congress and the President would have to sign a bill, sign a land withdrawal bill, and the Department of Energy would need to actually build a repository with tens of $billions in appropriations over the next few years. Is that about right?
That is all correct, sir.
So, Mr. Chairman, it's clear to me that the NRC and the DOE do not have sufficient funds to complete the Yucca Mountain licensing, and there's still a lot of public opposition in the state of Nevada. The Court of Appeals decision doesn't change either one of those facts. It's time for us to start in the subcommittee to start grappling with the tough policy questions we need to answer in order to establish a new consensus-based siting process that has a real chance of getting a repository built. With that, I'll yield back.
Jen yields back his time. Chair now recognizes the gentleman from Pennsylvania, Mr. Pitts, for 5 minutes.
Thank the gentleman. Apologize for coming in and out. We've got a couple of hearings going on at the same time. Chairman McFarlane, in your written testimony, you state, quote, in September 2008, the NRC staff adopted the EIS subject to additional supplementation on groundwater analysis. On October 2008, the DOE had notified the NRC of its intent to supplement the EIS. Subsequently, in July of 2009, the DOE notified the NRC that it had decided not to prepare a supplement to satisfy National Environmental Policy Act, NEPA, obligations. The EIS would need to be supplemented, end quote. Now, I have here a report dated July of 2009 from DOE's Office of Civilian Radioactive Waste Management entitled Analysis of Post-Closure Groundwater Impacts. And this document notes the NRC staff September 8, 2008 adoption report regarding the DOE's environmental impact statements, EIS, and indicates, quote, in response to NRC's staff adoption report, DOE has prepared this analysis of post-closure groundwater impacts. This analysis, post-closure groundwater impacts, addresses the information identified by the NRC staff as needed to supplement DOE's environmental impact statements, end quote. I have another document here from the NRC's website indicating that the supporting documentation for this report was provided to the NRC's public document room and the NRC's file center. Dr. Lyons, do you know whether DOE provided NRC the groundwater analysis Chairman McFarlane mentions in her testimony?
The report that you referenced, sir, was provided by the Department of Energy, and it was at least the understanding of our staff at the time that the supplemental details would be added by the NRC to the EIS. That could be revisited if the NRC wishes, but yes, we have provided that documentation as you cited.
Chairman McFarlane, is it possible that your staff made a mistake and that DOE did actually send the supplement that you need for the EIS?
My understanding is that we still need the supplement to the EIS, but I can get back to you with a longer answer for the record.
Did you want to respond, Dr.
I think we're both saying the same thing. The EIS needs to be supplemented. The question is, We think we have provided the information to the NRC to do the supplement, but if they wish us to do it, we would use the information that we provided to them. There may be a misunderstanding simply on who was going to write the supplement, but we provided the information.
Well, is there an open action item here, or can we cross this off the list of things that you folks need to do, comply with the court?
Clearly, the supplement needs to be completed, and this is one of the other steps that would have to be done to complete the licensing process, and it's a step that we would have to try to understand the resource allocation for, and whether it would be the Department of Energy who would take this on or the NRC.
Okay,
so this is something that needs to be completed and needs to be decided how to move forward.
Now, this administration shut down the Yucca Mountain program, and the issue that brings us here today, contrary to the Nuclear Waste Policy Act, and stranding spent nuclear fuel indefinitely at plants across the country. Dr. Lyons, was there a scientific reason for shutting it down?
As we've testified in other hearings, our concern has been whether this is a workable solution to move forward, and our belief that without a consent-based process, it is not a workable solution.
Will the gentleman yield? So that's a no, Mr. Lyons? That's a no? That it wasn't a science-based decision to shut it down. That's what you said. You're saying it was a political?
The Department of Energy submitted the license application based on the technical requirements.
Your answer to his question was no. That it was not science-based, it was a politically based decision. That's fine.
Mr.
Gentlemen,
Shimkus,
I'll yield back to the gentleman from Pennsylvania.
we can debate what you mean by a politically based decision.
I'm using your words, not mine. You're the one who just meandered on that it wasn't a science-based. The question was it science-based? And you said no. It's a consensus-based analysis, and we've always heard the story before, so your answer to my colleague from Pennsylvania was no.
I've attempted to indicate the range of issues that were considered, sir.
We got you on record as a no. Gentleman from Pennsylvania.
Time has expired. Thank you, Mr. Chairman.
Chair now recognizes the gentleman from Georgia, Mr. Barrow, for 5 minutes.
Thank you, Mr. Chairman. And Chairman McFarland, I want to begin by thanking you for your personal interest in the expansion of nuclear generating capacity in this country. It's going on in my backyard in Georgia and next door in South Carolina, and you've taken a personal interest in this, and I want to commend you for that and thank you and encourage you to try and help us through this renewal of nuclear energy generating in this country. I gather that y'all want input from the interested parties as to how best to proceed. I want to offer some input as to how best to proceed, assuming that the Court of Appeals decision becomes final in the law of the case. I take it that the usual practice in cases of this sort is that the SER is formally adopted before you enter into any adjudicatory proceedings to rule on any contentions that raise objections to the SER. Is that correct?
That's correct.
There's no reason to depart from that in this instance, is there?
Well, it depends on the parties and the participants and their views. We do have to weigh them all moving forward.
I understand you have to weigh their views, but y'all get to decide how you proceed, how you go forward.
Right. I mean, we're trying to understand what we can do with the limited resources that exist
at the moment. And I guess the input that I want to offer is that it seems to me it would make very little sense to enter into any formal adjudicatory proceedings to rule on any contentions that raise objections to the SER before the SER is even adopted.
Yes.
And my whole point is the input that I would offer is it would make no sense whatsoever to be having hearings on objections to the SER before it's adopted, then at some distant time in the future have it adopted, then have post-adoption contentions raising further objections you rule on later on. Let's just keep it one step at a time, shall we? One war at a time, as Lincoln said.
I do very much so appreciate your input, and we'll take that into consideration as we deliberate and move forward.
Thank you very much. No further questions.
Gentleman yields back his time. Chair now recognizes the other gentleman from Pennsylvania, Mr. Murphy, for 5 minutes.
Thank you, Mr. Chairman. To both of you, the FY 2011 continuing resolution was the last time NRC and DOE received funding for the license review. Am I correct on that, Ms. McFarland?
Sorry, the FY?
The FY 2011 continuing resolution was the last time NRC and DOE received funding for license review. Am I correct, Mr. Lyons? Is that true as well?
I do believe that's correct.
And the purpose of that funding was to carry out the purposes of the Nuclear Waste Policy Act. Am I correct?
Sorry.
The purpose of that funding was to carry out the purposes of the Nuclear Waste Policy Act.
Yes,
Am I
certainly.
correct? All right. And Dr. Lyons, but DOE used that money for the opposite purpose, to shut down the Yucca Mountain program and attempt to withdraw the license application. Am I correct?
The FY10 funding was used for a shutdown of the program, yes.
All right. And Dr. McFarland, the NRC also used that money to suspend the license review, correct?
Correct.
Dr. Lyons, how much money from the Nuclear Waste Fund did DOE spend to shut down the program?
I prefer to give you a precise number. It was around $130 million, but we can give it to you precisely in writing.
I have $138 million. I just want to be sure. Let me know the precise number. Chairman McFarland, how much money from the Nuclear Waste Fund did NRC spend to suspend the license review?
I believe it was $7.4 million.
Okay, I thought it was a little bit more. Could you double check that number,
I
please?
can certainly double check that number.
So to both of you, so together your two agencies have spent, by my calculations, a little bit under $150 million of electricity consumers' money shutting down a license review that the court has now said you have to complete. So electricity consumers throughout this country paid for you to conduct the license review, not to scuttle it. So how will your agencies restore that money to its lawful purpose?
And in terms of the Nuclear Regulatory Commission, this is actually an issue that's under adjudication right now, and so it's not appropriate for me to comment.
Are you going to have the money to do that?
Sorry?
Are you going to have the money to restore
Again,
that?
this is an issue that we've asked the staff to collect information on all budgeting.
And Dr. Lyons, do you have a different answer on that? Do you have any idea where the money's going to come from?
In my written testimony, I gave the numbers for the currently available funds that we have, either unobligated or costed and obligated.
I appreciate that, but I'm trying to get to the point that isn't it fair that you have to restore that money back to what its legal purpose was for? Am I correct?
The position of the administration continues to be that if we want to stop wasting money, we should be moving in a direction to a workable.
Would the gentleman yield for 1 second?
Yes.
Aren't you saying that the NRC and the DOE spent $150 million to break the law?
That's what I'm hearing, and now you're talking about something else. Look, we need a straightforward answer on this. You know, the fairness to the American people who've been paying these rates is that money was misused by DOE and by NRC. And so now when I'm asking you, are you going to work on a plan to restore that? You're talking about finding other ways to not waste money. This was a colossal waste of money. So now I don't understand. So just give me a straightforward answer. Isn't it fair that you find a way to restore that money to its lawful legal purpose?
I'm not aware, sir, what that mechanism would be. Perhaps someone on your side is. I'm not aware what that mechanism.
Oh, no, it's not my responsibility to fix your problem. Your breaking the law is not my responsibility to fix it. The misuse of money from your agencies is not the responsibility of the American people to come up with another answer. It's your responsibility. We're going to hold you to that. Chairman McFarland, in your testimony, you mentioned the NRC currently has $13.6 million available to fund resumption of the license review. Is that enough to fully comply with the court's decision?
Let me clarify. We have $11.1 million available and $2.6 million in obligated.
Will that be enough to complete the application review and issue a decision?
And issue the license?
Yeah.
Absolutely not.
But you're both legally responsible now for complying with the law.
We will comply with the law.
With the gentleman yield, ask that question on the safety and evaluation report. That's the question that we still need to get a firm answer from the chairman.
So let me ask that on the safety and evaluation report. Will you be able to comply?
We have asked the staff to update the information, update the resources needed to complete the safety evaluation report and to do a number of other activities. And as soon as we get that information, the commission.
So just to cut to the chase, it sounds like neither of your agencies has enough resources to complete the licensing review mandated by the court and by law. So when was the last time either of your agencies asked for funding in your budget proposal and to do any of this?
The last funding we received was FY 2010, to the best of my memory.
You haven't asked for any since then to comply? You have not asked for any since then?
That is correct.
Well, you'll be forwarding a supplemental budget request to fund these.
Until we know the requirements from the NRC until we have evaluated a path forward. It would simply be premature for me to speculate on whether that would be the course of action, sir.
Mr. Chairman, there's still follow-up here. No, you told, the law says you've got to comply. The court said you have to comply. You said you don't have the money to comply. And now you're saying it's speculation to find out if you're going to find. Now, this is a simple thing, that if your desire is to comply with the courts, and you're legally bound to do so by law, and you don't have the money to do it, I would hope that that's already in the works to say we're going to need more money to move forward on this and comply with the law. Do you have to hesitate on that?
I would give you essentially the same response, sir. It is just simply premature at this stage of the process to speculate what will be required of the department or to
I
commit
appreciate the
any
note you've been handed, but I'm asking you, this is
Gentleman's
easy.
time's expired. Chair now recognizes the gentlelady from California for 5 minutes.
Thank you, Mr. Chairman, and thank you to our witnesses today for your testimony and for being here. Nuclear fuel storage obviously is an important issue, and for communities with nuclear power plants, it's a very local issue. That's the case with my district. I represent San Luis Obispo, California, which is home to Diablo Canyon Nuclear Power Plant. Before I get to fuel storage, I wanted to follow up on an issue I raised with you, Chairwoman McFarland, last time you testified at this subcommittee, and that's the topic of seismic safety. We're seeing fresh reminders from Fukushima of just how devastating an earthquake can be if we're not fully prepared. And as you know, Diablo Canyon sits on both the Hoskree and the recently discovered shoreline faults. Last February, I asked you about a peer-reviewed study by Dr. Jean Harderbeck that concludes an earthquake much larger than current NRC estimates is possible along these very fault lines. I asked whether or not NRC is incorporating Dr. Harderbeck's findings into its safety standards for Diablo Canyon. Your written response states, and this is a quote, "The NRC staff believes that the views expressed by Dr. Harderbeck's paper will be fully considered by the experts involved in the seismic hazard reevaluation process." So my question is to give you an opportunity right now to update us on whether the NRC has taken any additional actions to address the concerns raised in this report.
So I believe that Dr. Harderbeck presented at the seismic hazard workshop, the second seismic hazard workshop that happened this past year, and her theories on the shoreline fault activity rate, the geometry, the fault geometry, and that will be included in the overall seismic hazard characterization model.
Does it involve any changes in or concrete actions?
Well, we'll see the results of the model at the next workshop, which I believe is coming up in the spring.
Okay, so we can expect a follow-up report after that time.
Yes.
We will stay in touch with you on that, and I appreciate that answer very much. And now to the topic at hand today, fuel storage. Given our inability to implement a permanent solution, my constituents are very concerned about Diablo Canyon becoming a de facto permanent storage site. I'm sure other facilities around the country may have the same concerns. I've been pleased to see more spent fuel being moved into dry cask storage at Diablo Canyon and also across the country. But these casks are really not permanent solutions. A few weeks ago, I asked Secretary Moniz about this, and he said the casks are safe for about 100 years. Chairwoman McFarland, do you agree with this estimate?
Well, we are actively trying to understand aging issues that are associated with casks. This is an important area of research for us at the Nuclear Regulatory Commission.
So you don't want to comment on his estimate of 100 years?
We licensed the casks for 20 years, and we have given a 20-year extension. We'll continue to see if further extensions are warranted.
Yeah, and obviously, spent fuel has got to be safely stored for much longer than 20 years, even if it's reauthorized, and longer than 100 years. My follow-up question then to you is, has the NRC evaluated on-site storage solutions that can safely store fuel for longer than 100 years? Because this, to me, is such a pressing issue for my constituents, but it certainly isn't limited to my constituents.
We're certainly looking at the issues of longer-term storage, both in the casks and in the spent fuel pools. So this is an area that we're actively considering.
I appreciate that. Well, I firmly support finding a permanent solution, but I really think it's critical that we have a backup plan. And can you tell me if there's one of those in the works?
A backup plan for, that's a policy
Sorry.
issue, and I defer to Congress to develop that policy issue.
Well, then I defer to the chairman of this committee that that's something that we want to consider in the nature of our, and to our ranking member as well, to the nature of our task, that permanent storage is a huge issue with nuclear energy.
Yeah, and if the gentlelady would yield, we currently have a law to deal with that, and we're just trying to force the administration to comply with the law.
All right, I yield back.
Gentlelady yields back. Chair now recognizes the gentleman from Mississippi, Mr. Harper, for 5 minutes.
Thank you, Mr. Chairman, and thank each of you for being here today. And Chairman McFarland, you just said regarding a backup plan, you said I defer to Congress for that issue, but didn't Congress set the law that's been ignored that's the source of the opinion that was just handed down in August? And so we have that. Yes, you say that, but we've dealt with another experience through this. But I wanted to ask you some questions if I could. And I understand, Chairman McFarland, that several parties have signed a motion questioning your impartiality and requesting your recusal, and that you decided, I believe last night, not to recuse yourself. Considering the motion for your recusal was pending at the time, I want to know, did you participate in the Commission's order for the parties to submit comments by September the 30th?
I did take part in that, and that was a ministerial issue.
Do you know Angela Coggins, the former Chairman's Policy Director and Chief of Staff?
No, I do not. I have never met her.
Are you familiar with her role in the closure of the license review as described in the NRC Inspector General's report dated June 6, 2011?
No, I am not.
But you do know now that she is working in the high-level waste section of the General Counsel's office?
No, I did not know that.
Well, those are things you might want to take a look at, and I would encourage you to do that. And I would ask, too, that you review her past actions, review that IG report, look at her current role, and then and answer back to us, if you could. Let us know, given her past actions on this issue and her ability to influence future actions, given her position, don't you think this contributes to the appearance that you're unable to be impartial? And I'd like for you to answer that question, submit that in writing back to the committee after you've had a chance to review that and determine the position and history of Angela Coggins. Now, Chairman McFarland, as the IG indicated in his report, the former chairman believed that stalling the public release of the SER volumes was within his responsibility to manage the staff. Do you believe that conforms to your responsibility as chairman to uphold the President's commitments for transparency and open government?
I'm sorry, could you repeat the question?
Certainly. As the IG indicated in his report, your former chairman believed that stalling the public release of the SER volumes was within his responsibility to manage the staff. Do you believe that conforms to your responsibility as chairman to uphold the President's commitments for transparency and open government?
I can't comment on the actions of my predecessor.
You're not aware of the history and the actions and the history of your agency?
I'm not aware of the details of what occurred to do with Yucca Mountain.
Are you not aware with the IG report?
I am aware that it exists, but I have not read it.
Okay, and you've been in your role for how long?
For a year and 2 months.
Wouldn't you think that during the course of a year and 2 months, and hopefully by the time you've been there a year and 3 months, that reading your IG report would be something that would be very important?
It's certainly an important issue. We have a large mission at the Nuclear Regulatory Commission to oversee the safety and security of over 100 reactors and over 20,000 materials licensees. We have quite a bit on our plate. And until August 13th, Yucca Mountain was not an active issue.
Well, it was an active issue under the laws of this country, but your agency chose to ignore Congress, even though you've said here today that you defer to Congress for a policy issue. There was a set law, and you ignored that, did you not? Not you personally, but your agency, and certainly now you've had it for a year and 2 months. But wouldn't an IG report be something that would be very important to be aware of, and your role to make sure that you don't fall into any of those problems in the future?
Let me assure you this, that all decisions on the matter of Yucca Mountain will be full commission decisions, and we will act collegially. We have been, I think my record shows, we have acted over the last year and 2 months very collegially on all issues, and that's how it will work moving forward.
But your agency unilaterally decided to ignore the law of this country. And now, because the courts finally recognize that the executive authority has overstepped their bounds, that we're now back trying to take care of something that should have long been done before. And I hope you understand our frustration. We want your agency to succeed. We want this to work for our country. And we urge you to continue to look at this and this concern that we have, and I yield back.
Gentleman yields back his time. Chair now recognizes gentleman from Florida, Mr. Bilirakis, for 5 minutes.
Thank you very much, Mr. Chairman. I appreciate it. Thanks for calling this hearing. The administration shutdown of the Yucca Mountain program in 2010, again, they shut it down. The ramifications of that shutdown are still reverberating. And the decision last year remanding the NRC's waste confidence rule, the D.C. court observed, and I quote, "At this time there is not even a prospective site for a repository, let alone programs progress toward the actual construction of one. The lack of progress on a permanent repository has caused considerable uncertainty regarding the environmental effects of temporary spent nuclear fuel storage and the reasonableness of continuing to license and relicense nuclear reactors. So the administration's actions to shut down the Yucca Mountain program have caused a federal court order to question the reasonableness of licensing nuclear plants. Dr. Lyons, if the administration really supported nuclear energy, wasn't it to reconstitute the Yucca Mountain program? Shouldn't they reconstitute the Yucca Mountain program, Dr. Lyons? Isn't it a demonstration that the federal government's will to follow the law the surest way to restore the waste confidence and provide a solid basis for the NRC to license? If you can answer that question.
Thank you for your thank you for your question. I noted in my testimony that we are already, as a nation, 20 years past the anticipated opening of Yucca Mountain. We are at an impasse. The administration's approach is to try to work towards a workable solution that can move us past the impasse and, yes, support nuclear power by providing a consent-based approach to move ahead on this vital issue of the back end of the fuel cycle.
Would you like to comment as well?
Oh, would I? Sorry.
Yes, please.
I didn't hear you. Not at this time.
Would the gentleman yield?
Yes,
the real question is, because of the delay and the stopping of Yucca Mountain, the waste confidence rule for interim storage has been attacked and is causing problems in local storage areas because we don't have a location. So now the waste confidence rule is up for litigation or review, which continues to cause additional problems. Isn't that correct?
No, they have nothing to do with each other, right?
They do have by the ruling and the statements Mr. Bilirakis just stated. The waste confidence rule was predicated on a long-term geological storage. When you walk away from a long-term geological storage, you upset the whole waste confidence rule. So I find it incredulous that you say they have nothing to do with each other.
Well, I say that simply because the court that ruled on the waste confidence decision required us to consider the case where there is no repository.
And there is no repository because the administration has broken the law to not proceed.
I can't comment on that.
But I can, and Mr. Lyons can. Is that why?
As we've testified repeatedly, sir, our general counsel supported endorsed our ability to withdraw the license.
So you're blaming your general counsel for making a ruling that you could break the law that upset the apple cart on the waste confidence rule.
And our focus is on finding a workable solution that can move this country forward.
And I apologize if I take my colleague's time. Where is the only vote from the legislative body on the floor of either chamber that talks about a bipartisan movement, Mr. Lyons?
Again, sir, we are trying to
You talk bipartisanship 4-1 by this chamber in the House 3 consecutive years in a row in supporting Yucca Mountain. So that's where the bipartisan agreement is, and it's about time that the administration started following. I yield back to Mr. Bilirakis.
One last question for Dr. Lyons. Do you believe that the science done by our labs, our national labs in support of Yucca Mountain license application is sound?
Yes.
Thank you. I yield back, Mr. Chairman.
Gentleman yields back time. Chair now recognizes the gentleman from Ohio for Mr. Johnson for 5 minutes.
Thank you, Mr. Chairman. I want to make a couple of comments before I start. Dr. McFarland, you made the statement in your testimony several times this morning. You qualified your answers with, "You must understand something." I hope that you understand something and that you have seen the resolve of this committee to hold your agency accountable to the American people and to the laws that have been duly passed by this Congress. We have multiple ways of doing that. It doesn't just involve hearings. So I hope you understand the seriousness with which we are approaching these issues. Dr. Lyons, in your testimony, you said maybe someone on our side has a mechanism for restoring those lost funds. You used the phrase "on your side." We're supposed to be on the same side. It's the side of the American people. And the way this system works is that Congress passes laws and the administration implements the law. Not sidestep the law, not avoid the law, not remake the law, but comply with the law. So I hope both of you understand that it doesn't stop here today. We're going to hold you accountable. I hope that's clear. Dr. Lyons, the NRC is committed to provide this committee with a monthly report detailing their actions and expenditures to comply with the court's decision. Will you make that same commitment to provide us with a monthly report on DOE's actions and expenditures as the applicant in support of the license review?
We'll be happy to commit to provide you with regular reports as there are events that lead to change.
I ask about our monthly report detailing the actions. Are you willing to provide us with a monthly report on the Department of Energy's actions and expenditures?
If you wish it monthly, so
a monthly
yes,
report.
sir. We will do it monthly. Our suggestion is that doing it when there's changes.
Well, no, I want a monthly report. This committee wants a monthly report, just like we're going to get from the NRC. Can you commit to that?
Yes, sir.
Okay, thank you. Initially, as the applicant, DOE advocated in favor of NRC granting construction authorization for a repository at Yucca Mountain. Later, DOE attempted to withdraw the application in such a way as to prevent the NRC from ever considering the Yucca Mountain in the future. In July, when testifying before this committee, Secretary Moniz was asked if DOE would honor the court decision, and he indicated that DOE would follow the law. So, Dr. Lyons, now that the court has decided and the law is clear, will DOE, as the applicant in this proceeding, once again advocate in favor of NRC granting construction authorization?
Our path forward remains under evaluation. It depends on the NRC's.
That wasn't the question. I'm not asking you about the evaluation. I'm asking you about what Dr. Moniz, what he said, what Secretary Moniz said, that DOE would follow the law. And so now I'm asking you a very simple question. Now that the court has decided and the law is clear, will DOE as the applicant in the proceeding once again advocate in favor of NRC granting construction authorization? Will you follow the law?
We will certainly commit to following the law, but
Great,
it's
that's what I
premature to
needed
say
to
what
know.
the exact
Next
path
question.
will be.
I'd like to follow up on some questions that I posed to Secretary Moniz in July. In your July 22nd response to Chairman Shimkus, you noted that DOE's 2014 budget requests money from the Nuclear Waste Fund to support storage and transportation activities for locations other than Yucca Mountain. Dr. Lyons, given the court's order, do you still believe that DOE is authorized to spend Nuclear Waste Fund money for purposes other than Yucca Mountain?
My response in that letter very carefully distinguished between generic R&D, which continues to be our focus, which is non-site
We're talking
specific.
transportation activities. Let me repeat the question because it must not have been clear. You requested budget request from the Nuclear Waste Fund to support storage and transportation activities for locations other than Yucca Mountain. Given the court's order, do you still believe that DOE is authorized to spend Nuclear Waste Fund money for purposes other than Yucca Mountain? Transportation activities, etc. Take your note, because I think your guy back there on the back's got the answer for you. I think the answer is you should comply with the law, right?
Anything that we are doing on transportation at this point is location neutral. On the specifics of exactly which...
If it's providing locations for any place other than Yucca Mountain, it's not location neutral. And that's not the purpose of the Nuclear Waste Fund, Dr. Lyons. So, given the court order, is it still your belief that DOE is authorized to spend Nuclear Waste Fund money for purposes other than Yucca Mountain? Because you and I both know what the law says.
Nuclear Waste Fund money will be spent on Titles 1 and 2 of the Nuclear Waste Policy Act. I'll rely on General Counsel as to exactly what falls within that category.
Clearly, I'm not going to get a straight answer, Mr. Chairman.
The gentleman's
I yield
time.
back.
The gentleman's time's expired, and we can pause, and we're done. So we want to thank the panel for being here. I have to thank you, and it's a tough issue. There's emotions rampant on both sides. We do appreciate you putting up with us, but you'll see us again, I'm sure. In conclusion, I'd like to thank, again, you all for being here and the members who participated, and remind my colleagues that they have 10 business days to submit questions for the record, and I ask the witnesses all to agree to respond promptly as possible to all questions. And with that, the hearing is adjourned.